Hello, aspirants. Welcome to another explainer right here at Rungta IAS Academy. I'm joined by my co-faculty. And today, well, we're unpacking a really sensitive but absolutely crucial topic for your UPSC preparation.
That's right. We are diving into the legal and ethical dimensions of adolescent sexuality. Now, if you look closely at your syllabus, you'll see this bridges General Studies Paper 1, Indian Society, and General Studies Paper 4, Ethics. So we're going to analyze this way beyond the newspaper headlines, exactly how an administrator would.
Okay, let's just dive right into this. Imagine you're sitting in the exam hall and you see this classic 15-marker mock mains question. Critically analyze the state's approach to adolescent sexuality in light of the MTP and POCSO Acts.
Spot on. This explainer is specifically designed to give you that exact structure, the right vocabulary, and the empirical evidence you need to score really high marks on a question just like this. We'll break down the context, the ethical dilemmas, the structural flaws, and then the way forward.
So let's start with part 1, the context, the Supreme Court judgment. You know, every good UPSC answer needs a really solid foundation, right? You usually want to start with a recent Supreme Court judgment or a strong case study. So recently, the Supreme Court allowed the medical termination of pregnancy at 28 weeks for a 15-year-old unwed minor. Now, here's the catch. The statutory framework, specifically the Medical Termination of Pregnancy Act amended in 2021, actually doesn't allow abortions beyond 24 weeks, even in exceptional circumstances.
Exactly. In this case, the pregnancy went completely unnoticed until it was very advanced. Doctors at Ames raised strong objections. They argued that terminating at 28 weeks literally involves delivering a living child, one who might face severe medical complications. They actually wanted to push the delivery by 6 weeks just to improve those survival chances. But the court, they prioritized the minor's reproductive autonomy and overall well-being, and they ultimately rejected the doctor's arguments.
Which brings us to part 2, the doctor's ethical dilemma. And this brings us squarely into the territory of GS4. What we're looking at here is a classic ethics case study. It's all about competing moral duties for medical professionals. On one side of the equation, we have the viability of a 28-week fetus. Because it's such an advanced stage, it's not just a standard abortion, it's literally a medically induced premature delivery. This immediately places a massive ethical burden on the doctor to preserve that newborn's life.
Right, and as a future administrator, you have to recognize something crucial. A court order might protect the doctor from legal action for sure, but it doesn't just erase their moral obligations. On the other side, we have the immense trauma of a 15-year-old unwed minor. She had reportedly attempted suicide twice, so the doctor's duty is also to prioritize her mental and physical well-being. It's a huge anxiety point for these professionals, balancing the life of a viable fetus against the urgent reproductive autonomy of a deeply traumatized young girl.
Moving on to part 3, structural failure and state policy. Now, shifting our lens over to GS1, Indian Society. We have to realize these ethical tensions aren't just rare anomalies. They are symptoms of a much deeper structural issue, basically a serious failure of the state to handle teenage sexuality. If you're writing this in your mains exam, you can structure your critique around 4 flawed state approaches. First up, the state relies heavily on blanket criminalization under the POCSO Act. It treats all adolescent sexual activity as a crime, completely ignoring de facto consensual realities. Second, we see these kind of superficial policies, right? Like banning condom advertisements between 6 a.m. and 10 p.m. Third, we lean way too heavily on abstinence-only approaches. Global studies have proven time and again that these simply do not stop adolescents from having sex. And fourth, our generally repressive culture just sweeps these issues under the rug. We reduce complex, vital sex education to a simplistic, just don't do it. So the crucial takeaway here is this specific statistic, 10 to 15%. As aspirants, you absolutely must memorize this figure. It's the perfect data point to back up your arguments about why blanket criminalization is failing.
Let's actually look at where this number comes from and why it proves that our current legal framework is pretty out of touch with ground reality.
Faculty 1 empirical evidence from multiple studies repeatedly shows that nearly 10 to 15% of all cases sitting before POSO's special courts actually involve de facto consensual relationships between adolescents.
Yeah, and in the very case we were just talking about, it was a 15-year-old girl and her 17-year-old partner. There's literally nothing to suggest that the POCSO law deters these interactions. Instead, this criminalization just works hand in hand with a total lack of comprehensive sex education. And the result? Tragic outcomes like late-stage, extremely high-risk pregnancies.
Which leads us to part 4, the way forward and having a nuanced dialogue. We can never just leave a UPSC answer with pure criticism, right? We have to provide a constructive way forward that highlights policy solutions over mere rhetoric. True policy reform means we need a highly nuanced conversation. We have to stop conflating de facto consensual adolescent interactions with horrific instances of child rape and exploitation.
Absolutely. The real solution is a fundamental shift in how the state handles adolescent reproductive health. We need to engage with it honestly rather than pretending it doesn't exist. That means we have to prioritize steady, long-term measures. Things like teaching the essentials of safe sex, menstruation, and STDs in schools. We have to do this, even if it doesn't provide any short-term political gains.
So, to wrap up today's explainer, we want to leave you with a rather provocative mock interview question. Just imagine you are sitting right there before the UPSC panel and they ask you, if you were the health secretary, how would you balance the MTP Act limitations with adolescent reproductive health? It's a tough one, right? Think about it. How exactly would you integrate the ethical dilemmas of the doctors, the autonomy of the minor, and the desperate need for structural educational reforms? Ponder on this, sketch out a structure in your notes, and keep studying hard. Thank you so much for joining us for this Rungta IAS Academy Explainer, and we'll catch you in the next one.